Yes, but that sets me up perfectly to segue to the next thing that we wanted to cover, which was something that you did this week with ChatGPT to explore some of these laws and figure out which parts are hidden and which are not. And so this is something that you wrote up on the Stanford Cyber Law blog around ChatGPT saying the quiet part out loud. So do you want to describe what it was that you found and what you did?
Sure. So this was so fun and exciting for me. I was really surprised by the answers I was getting from ChatGPT, and I wound up, staying up late playing with it. But so I started with a version of ChatGPT that was put together by someone who was at a trust and safety vendor called the Trust and Safety Regulation Expert, ChatGPT. Yes. And what I think that means is that in addition to having whatever the background training materials are that ChatGPT has, there was also additional information entered as prompts to sort of set up this one to have more or better answers than regular ChatGPT. So I asked it questions like, what must I do in order to comply with the California Age Appropriate Design Code, the draft of KOSA that's in the Senate right now, Europe's Digital Services Act? And the answers should be, if you listen to the proponents of all of those laws, the answers should be like, build good systems and risk mitigation practices, things that are kind of hand wavy. But this is an instance of ChatGPT that's trying to tell you how to do compliance. It's aimed at the people doing the work, and they need something more concrete than that. And it turns out that something more concrete than that is ChatGPT says, take down the following categories of content. And so for the US ones, so list sexual content, which is the one kind of content that the Supreme Court has consistently said can be legally restricted for children, and you can have reasonable laws trying to achieve that. And then we can debate what a reasonable law is. But then it also lists violent content, which we know from the violent video games case is something California has failed to restrict from children before. Dangerous challenges, cyberbullying, self-harm and suicide, eating disorders content, hate speech, also something the Supreme Court has recently emphasized as generally constitutionally protected speech. So it lists these things that those are terrible content. I don't particularly want kids seeing that stuff, or at least the bad version of that stuff. Of course, if you read the list literally, it would exclude all kinds of educational material, classic literature, things that are taught in high school, comic strips, lots and lots of things. But what was striking is just that it is a literal list of legal kinds of speech that ChatGPT thinks you have to take down or you have to stop kids from seeing in order to be compliant with these laws. Full stop. And that's exactly what the AG's office in Bonta was trying to insist the law didn't mean.
Yeah.
And you get, ChatGPT, I think, arrived at the same answers that anyone trying to comply with this law would probably arrive at. This isn't some kind of hallucination. This is just being realistic about what these laws actually require and probably reflecting what a bunch of online coverage or recommendations of best practices for vendors or, whatever, what they say you're supposed to do to comply. So I think it really is saying the quiet part out loud, and it's refreshingly blunt and straightforward.
Yeah. And this is, one of the things that comes up in these discussions is how would you comply with these laws? And as much as the politicians and regulators say that it wouldn't require removal of content, the reality is that a lot of companies are going to read these laws this way, in part just to avoid even having to litigate it, right? The problem is that so many of these things are vague and vaguely written, and you don't want to have to be in court defending this because that would be crazy expensive. And the way to avoid that is just to remove all this content. And then you get to this point where effectively the law is requiring you to take down protected speech. And that's what the Ninth Circuit saw. It was interesting to me also because you did sort of two separate questions on this. You talked about the AADC and KOSA, but you also did it with Europe and the DSA, where, as everyone in Europe always reminds me every time I talk about European regulation of the internet, there is no First Amendment and they have different standards. But there are lots of European officials who have insisted, to my face at times, that the DSA is not intended to regulate speech and is not intended to require sites to take down speech. Yet, as we have talked about, Terry Breton, who is effectively in charge of the DSA, seems to think otherwise, and ChatGPT seems to agree with him.
Yep. Yeah. So in Europe's defense, they have human rights instruments that protect free expression. They just draw the line between what's protected and what can be prohibited under law in a different place than the US would. And so I think the fundamental question is identical in Europe versus the US. It's for whatever that slice of speech is that's lawful but awful, that's not prohibited by law, but that lawmakers wish they could prohibit, or that, most people find offensive or harmful or, morally abhorrent. For that slice of content, what can laws get away with doing?
Right.
And the part of the DSA that I think that comes closest to being like the AADC or KOSA and being like, oh, here's a sneaky way of getting platforms to take down lawful but harmful content. That part is the risk assessment and risk mitigation rules for the very large online platforms in Articles 34 and 35 of the DSA. Those say you have to do an assessment of the risks that your platform poses to this whole list of really important societal values: safety of children, privacy, free expression, violence, civil unrest, et cetera. And having assessed the risk of everything that might go wrong in a society, then you say how you're going to mitigate that risk.
Right.
And is the answer that you, as a platform, have to mitigate that risk by taking down lawful speech? Well, Terry Breton seems to think so. I was recently at a multi-day event in Brussels about this specific issue, like just these articles at the DSA, and a bunch of experts there were like, no, actually, obviously, like they didn't even think it was a question. Obviously, you're supposed to take down this harmful but lawful speech. But that is absolutely not what the commission was saying the law was supposed to mean when it was being drafted. I have a really strong quote on that in my blog post of how they were framing it, and I think sincerely framing it. I think they truly wanted this to be a law that is about systems, but that didn't give government the authority to push for removal of specific kinds of harmful but lawful speech. Well, turns out ChatGPT, like Commissioner Breton, think that is what the DSA requires. And so it told me to remove quote unquote harmful speech, which is the sort of has been the buzzword for this lawful but awful category in the DSA discussion. And it also told me to do something that crosses an enormous, important, bright line in EU law, which is it's been a legislative rule for a very long time that government can't compel platforms to do quote unquote general monitoring of users' communications. You can't make them go out and search for every time a user says something that violates the law. And the highest court of the EU has said repeatedly, this is not just a legislative rule, it also protects users' free expression rights from the over removal that comes from filtering speech, and it protects their privacy and data protection rights. This is a really important rule. You can't make platforms engage in general monitoring. Now, there's some holes in that rule, which we can talk about another time. But ChatGPT just blows right past that and says, go out, do proactive monitoring, use the tools vendors want to offer you, find the bad stuff and take it down proactively. So it's really going against, it's passing two really important red lines. One is telling platforms to take down lawful but harmful speech, and the other is telling them to do general monitoring.
Yeah. And there is a response that some people can have for this, which is like, well, this is ChatGPT. It's not a lawyer. ChatGPT is prone to hallucinations. But I think the important point here is that like this is a fairly standard way that these laws will all be, and in some cases already are, being interpreted. And the fact that ChatGPT always seemed to come to that same conclusion with all of these laws, and these are the ways that people warned about that the laws could be interpreted, and just the fact that, and this sort of gets left out of the debate, but I think is an important point, which is that companies are liability averse. Like they don't want to risk this stuff. And so if you give them something where they might face liability and you give them an easy out to avoid that liability, they are probably going to take it. We had a post about a month ago about KOSA in particular by Matt Lane, who was talking about like the laziness of companies in terms of how they will deal with these laws. And it is like, they don't want to fight it out. So they're just going to remove the content because that is the easiest and that avoids even having a lot of these questions.
Absolutely. And there are so many shortcuts like that. For example, if you are a company and you don't want to deal with the slight differences in hate speech law or privacy law between France versus Sweden versus Romania, you just expand your terms of service to prohibit all of it.
Right.
And then that's, much cleaner and easier. And that's the same kind of shortcut that we should expect in the face of an ambiguous legal mandate. I also think the biggest platforms, the very biggest ones, have lawyers who can parse this carefully and who know what the commission has been saying this means, et cetera. But anyone else looking for advice on this, they're going to look at whatever the secondary literature is on the web. And that's the same secondary literature I think ChatGPT must have mostly trained on. And it says these sloppy things about taking down harmful speech.
Yeah. And just to note, because I think there might be some people listening to this who are like, well, what's the problem here? If we're talking about harmful content, why not just remove it? And I think I'll just point out that turns out to be a lot trickier of a problem than people make it out to be. Because what counts as harmful content, and harmful to whom, and harmful how, and do you include content that might be LGBTQ useful content that some people consider harmful and some people consider life-saving? Determining these things are really difficult. I talk about the eating disorder content issue quite a bit because that comes up as one of the examples of harmful content that people talk about a lot. And yet many of the studies have found that when that content is removed from platforms, it actually makes the problem worse, not better, because people continue to seek it out, and they tend to seek it out in deeper and darker places that have fewer protections and, importantly, fewer mitigations. When that content is found on platforms like Instagram or TikTok, they will often include some sort of mitigating content saying, warning people or pushing them towards resources for recovery, whereas the deeper, darker places of the web don't do that. And so I always like to raise that because sometimes you get into this discussion and some people I know are listening saying like, but no, like that's bad content. It shouldn't be allowed at all. And I just want to remind people that it is often trickier than people think it is.
It's tricky and it's so inextricable from this sort of culture wars backdrop.
Yes.
These are laws that have a vague concept of child safety, and then someone has to be the enforcer to decide what content is or is not safe for children. And so the concerns that LGBTQ groups have been raising, I think, are incredibly compelling about conservative AGs saying what child safety means, or conservative FTCs under a Trump administration saying, what's harmful to children is information about reproductive choice or information about transgender identity. And Marsha Blackburn very much said the quiet part out loud on this, such as saying that we need to protect children from quote unquote the transgender. And so the, parts of the left that are paying attention have been rightly very alarmed by these laws. But recently we've seen parts of the right appropriately get alarmed in the exact same way. We have Rick Santorum and pro-life organizations saying, wait, what if a liberal attorney general or enforcer wants to override our values and preferences about what our children should see? And they should worry about that.
Yeah.
I'll say one more thing about the speech at issue, moving away from the kind of fraught culture war questions. There's this beautiful brief that I just love, filed in the lower court as an amicus brief in Bonta by the New York Times and the Student Press Law Center. I link from it in my blog post. And the second half of the brief is just like moving stories about student activism and journalism and how important it is for teenagers, especially, to like see the upsetting things that are going on in the world on the news and not be protected from that. And I just think it's such an important point, and it's so impossible to isolate the good and productive upsetting information in the world that kids need to see from whatever it is that these laws want platforms taking down.